Our third speaker tonight comes by a rather interesting route which he doesn't know about, so I'm about to tell him. So the question was put out, who is a really amazing young Māori person with a great sort of legal mind, respected by people of his own generation or her own generation? We were, equally looking for both genders. And this, dare I say, this person was the person that was most recommended by people of his own generation, by professional colleagues, and by Māori. So I'm very pleased to introduce Isaac Hikaka, who is a partner at specialist dispute litigation firm, which I'm reading because it's all one word, Lee Salmon Long. There are no spaces. And he is somebody that we hoped would, and I'm sure will be, the voice of the future generation for those of us that are quite a bit older than him. So welcome, Isaac. I hope you liked the story of how you got here. Kia ora.
Kia ora rā tātou katoa, ko taranaki te maunga, ko Aotea te waka, ko Ngārua hine te iwi, ko Ngāti Tūmahuroa te hapu, ko Hikaka te whānau, ko Oyo te marae, ko Greg te matua, ko Jolene te whaia, ko Isaac Tamakitarangi Whionbara Hikaka hau te hei Māori ora. Thank you for the privilege of addressing you today on Magna Carta and the Treaty of Waitangi. I was very surprised to hear my introduction and wish I'd heard it beforehand, because then I could have disabused the people of the notions that have just been put to you about me. But there have been a large number of speeches made about the Magna Carta this year from very learned persons, and it's already been pointed out today that it's impossible to say anything new about the Magna Carta unless one says something mad. Now, I do not suggest that I will say anything new, though there is a much greater chance I will say something mad. What I would like to do is suggest some links, or potential links, between the Treaty of Waitangi and the Magna Carta, and I'll address three aspects. First, I will suggest that there are a number of historical similarities in the treatment of Magna Carta and Te Tiriti. Both were signed in response to particular historic circumstances. Both then went through a period of being ignored or devalued, and both went through a period of rediscovery and reinvigoration, that period we are in now. Second, I will examine the notion of the rule of law and how it is important in both documents. I will suggest that not only is the concept of the rule of law present in both documents, but the underlying principles of that doctrine would not have been foreign to Māori in 1840. And finally, I'll seek to illustrate an important difference between Magna Carta and the treaty, and suggest how this difference can be viewed in a more global jurisprudence of constitutional interpretation. So, though signed centuries apart, there are some similarities in the historical stories, or narratives, if you will, of Te Tiriti and Magna Carta. Both were signed to address particular concerns and in particular circumstances, and it was these circumstances and concerns that framed the language of the two documents. In Magna Carta's case, the document was a temporary peace agreement between King John and his barons, and responded directly, though not necessarily comprehensively, to the concerns that had led to the rebellion in the first place. In its long and archaic text are littered provisions about taxation, river weirs, and repayment of dowries, some of which have precious little resonance to the modern audience, but had significant import to those feudal landowners who thrust the articles of the barons before a rapacious king in a muddy field. But just as the climes of Waitangi were, I imagine, much more hospitable than those of Runnymede, so too were the circumstances that led to the signing of the Treaty of Waitangi. There was no state of active hostilities between Māori and the British Crown that was to be resolved through the treaty. Rather, the Crown is likely to have seen the treaty as being for the benefit and protection of Māori from the ravages of lawless settlement and the French, though the British Crown might have seen little difference between lawless settlement and the French. And to the outside observer, the inherent self-interest in the Crown's position is obvious. But it was this context and attempt to obtain sovereignty by treaty that explains the character and language of the document, or at least its English language version. Of course, whether it actually achieved that aim of sovereignty, especially in the light of the recent Waitangi Tribunal report, is a much more vexed topic. The second stage of similarity is the ignoring of the two documents soon after their signature. In the case of the Magna Carta, it was only a matter of weeks before the terms were broken, and in a matter of months it was denounced by the Pope. Though it was reissued, albeit in somewhat watered-down versions, by successive kings until 1455, it ceased having any practical effect until around the late 17th century, despite extensive efforts of Edward Coke in the early 1600s to buttress his challenge to an absolutist monarchy. In New Zealand, the active disregard for te tiriti throughout the early colonial history is well known. Though Chief Justice Prendergast's dismissal of the document as a legal nullity in the case of Wiparata and the Bishop of Wellington was less juvenile than Oliver Cromwell's dismissal of the Magna Carta, it was no less troublesome. Early colonial governments took many actions, some of which you've heard about already, that were clearly in breach of the treaty. I mean, there's no sensible way to defend legislation such as the Native Lands Act 1865 as consistent with the treaty. But, on a happier note, as alluded to earlier, we're now in a third stage of the process where both the Magna Carta and te tiriti have been reinvigorated. In terms of Magna Carta, that can most obviously be seen by the fact that we are here celebrating its 800th anniversary. Images of its ceiling adorn the doors of the United States Supreme Court and sit above the doors of the United Kingdom Supreme Court. While it may be that celebration of the document is more a celebration of what it has become more than what it was originally, this doesn't lessen its significance. Its position as a founding document in the Western legal system is secure. And so too, I say, has the Treaty of Waitangi emerged as the most important document in New Zealand's constitutional history. Its recognition through the legislature and the courts have enabled it to take a central position in New Zealand's political and social dialogue. It is a mainstay of our education system and a mainstay of our legal system. Though it has not obtained the same uncontroverted status in the minds of the New Zealand public as Magna Carta has in Great Britain, it is something that has been taken up by successive governments as a guiding policy toward Māori, and something they've made extensive efforts to remedy the past breaches of. So on the topic of the rule of law, Lord Sumption, whose speech you've heard about earlier, in a recent address to the Franco-British Council Conference, noted that Magna Carta is one of those documents which is important not so much because of what it says, as because of what people wrongly think it says. Now, notwithstanding that, even His Lordship acknowledged that Magna Carta stands for the rule of law. Articles 39 and 40 of Magna Carta are justly its most famous clauses, and it is appropriate that they are the clauses that endure on the New Zealand statute books through Article 29 of Magna Carta 1297 and Section 3, of the Imperial Laws Application Act 1988, to prove that I know some statutes. The rule of law is most conveniently summarised as a principle as the requirement that power must be exercised in accordance with law rather than on a whim. Though not a principle created by Magna Carta, that document has become the touchstone for the principle in modern democracies stemming from Great Britain and Great Britain's colonial exploits. However, it is not a concept unique to the British legal tradition. As the Waitangi Tribunal has recently noted, Māori had their own system of laws and authority. The Māori system of law centred on the imperatives of tapu and utu, handed down by atua, but interpreted and applied in the temporal world by rangatira and tohanga. So where Article 3 of the Treaty of Waitangi guaranteed to Māori the rights and privileges of British subjects, including the rule of law, the translated phrase for that of tikanga katoa would have been recognised by Māori as a system of law and not a system of whim. The final point I wish to make is based on the difference between Magna Carta and Te Tiriti. As I noted earlier, much of Magna Carta's importance is based on its mythic significance rather than its actual words. Though arguments have been made that in Magna Carta one can, if we adopt the words of Lord Neuberger, detect the green shoots of democratic government, freedom of expression and economic prosperity, in my view, one has to strain very hard to actually read such grandiose proclamations into Magna Carta's text, the rule of law being an obvious exception. And I say that's not surprising. As referred to earlier, Magna Carta was a product of very particular circumstances, and those circumstances did not include a desire to make a provision for the majority of the British population. In contrast, the Treaty of Waitangi was specifically aimed to provide for all Māori, though not necessarily in a directly enforceable way. Though significantly shorter, Te Tiriti's words provide a more direct and broad basis for the recognition of a wider range of rights relevant to modern society than those addressed in Magna Carta. To this extent, I suggest that the Treaty of Waitangi can be seen as closer to being a foundational constitutional document, such as the Constitution of the United States of America, than the actual Magna Carta document. Similar interpretation conventions should appropriately apply in reading Te Tiriti in a manner that responds to contemporary issues as a living document, if you will. A recent example of this principle of interpretation, probably the most recent example, is the majority decision of the US Supreme Court in the Obergefell and Hodges decision, the gay marriage decision. And that same principle is a convention that New Zealand courts and the Waitangi Tribunal have adopted. So whereas Magna Carta has developed its importance less through what it actually says and more through what it represents, the languages and circumstances of Te Tiriti are such that its importance need not be created through romanticism. Having regard to its position as a constitutionally significant foundational document, in my view it is appropriate to consider Te Tiriti to be akin to a Māori Magna Carta. Nō reira, mauri ora kia koutou katoa.
So what do you think? Did he live up to the hype of his peers? Yes, I think so very much. Well done, thank you so much. That was incredibly interesting. And actually, I think it came so much from the heart that it made it even more impressive. So thank you all. I'd like to thank all of our panel members very much. I'm going to give you all a moment to just think about any questions that you might like to ask.